Everybody hear me? Am I close enough to the mic? Sometimes a little more? Okay, sorry, I mumble sometimes. I'm not much of a public speaker, so yeah, you'll glean that as we go. Like Linda said, I'm Steve. This is Shane Hansen. We're really lucky to have Shane with us here today for a couple of reasons. The first of which is I've done this presentation twice on my own. Some of you have seen it. It gets rather dry, it gets rather boring, and nobody wants to hear me talk for that long in a row. My wife would attest to that. Especially when it's about what I do for a living. Secondly, Shane is one of the most respected attorneys in the securities industry, and he's very knowledgeable, and the color that he's going to be able to add to this presentation is going to be great. So if there's anything you want to add before we go, you want to get started?
Hey, no, I'd only add, can you hear me? Okay, and that ask questions. We want to make this interactive, because if you hold them to the end, you'll forget them and it'll be out of context, and so just stick your hand up. We've got the guys who've got mics, so because it's recorded, make sure you are speaking into a mic, so wave your hand. The guys up and back have got the mic, so get that first and ask questions.
Yeah, please feel free to do that. This next slide is probably going to be Shane's favorite among them. I can't give legal advice, but given that he's in the business, he can, probably for a price. But the views that I'm going to express here, aside from the actual content of the rules, are my own, not the department's, not the department directors, not my bureau directors, not my division directors. We have a lot of layers of bureaucracy. If you have something that's a sticky issue, get legal help. Don't be afraid to reach out to an attorney. So as far as an overview goes, we're going to give a brief history of where we've been, why we're implementing new rules now, what the rules are replacing, which kind of gets into the history. What are the new rules? We're actually going to go through them one by one and give a brief overview. Again, you've got a copy of them. This is not going to be a holistic word-by-word review of what they are. It's just an overview. Again, to the extent you have questions, raise your hand, ask, yell at us if we don't see you. So, as far as history goes, 2008, the new Securities Act was passed by the legislature. It took effect on October 1st, 2009. Thereafter, the administrator of the Securities Act, which was with the Office of Insurance and OFIR, Financial Insurance and Regulation, got transferred to Lara in 2012. The director of the Corporation Securities and Commercial Licensing Bureau was appointed as the administrator of the act, and that's where we are now. In 2015, which I realize was a number of years ago, we undertook to do a new rule set to replace the transition orders, which were really meant to be temporary. Again, it was 2009 that the first of these really came out. So when you think about it, it's been 10 years and we still don't have effective rules until July. It's been quite a process. So we completed that process when the rules were filed with the Office of Great Seal on January 3rd of 2019. They take effect July 3rd of 2019, with the exception of one of Shane's favorite rules, which he'll touch on later, the private fund advisor exemption, which will take effect 1 year from the filing, which is going to be January of 2020. So that's as I move the lectern there, it's on wheels, I just found out. That's going to take effect in January, of next year. So why? As I mentioned, it's been a long time since we've had any rules. It's been since the 80s. The way that our regulatory structure is set up, it hasn't been updated in a very long time. So in that time period, obviously the industry's changed a lot, the world's changed a lot, and the way people do things has changed a lot. Our structure hasn't been built in a way to keep up with that. So what we're doing is really wholesale replacing what we've got with things that have been implemented through primarily NASA model rules in the last little bit to really bring us more up to what the rest of the country is doing. Where we were, the transition orders I mentioned, and effective July 3rd, we're going to rescind all of these transition orders with the exception of portions of Transition Order 6 that cover private fund advisors, primarily again due to the delayed effectiveness of that rule. I'm not going to read all of these for you because it's just not worth the time. You can go look at them if you want. They essentially set up our regulatory structure from how you register to what's required for an IA contract. There's a securities product exemption for not-for-profit securities, et cetera, so on and so forth. To the extent you want to see these, they're on our website, but I would expect that most of you are familiar with their existence, if not their content at this point, since they have governed the regulatory structure. Anything you want to add on those?
No, I would add, it's great to replace them because they were issued over a series of a couple years, and a couple of the modified earlier ones, so you almost have to read them all, maybe in reverse order, to sort of sort out what the current requirements are. So this is great.
Yeah, and when you do go through them, it can be a little confusing just because you look at, I want to say it's transition order 3 or 4, but there's so much strike bold in it that you can't figure out where it starts and where it ends. So it'll be very nice to just have the rules. So there are 5 parts to the rule set. You've got part 1 is definitions, part 2 is securities exemptions, part 3 is going to be registrations and notice filing, part 4, which I imagine most of this room, I guess before we dive into that, just a little survey of who's here. Registered IA, IARs, just hands up. Wow, huge majority of the room. Are you registered as a broker-dealer, agent of a broker-dealer? Got a couple, smattering. Lawyers? My favorite people, yes. So part 4, I imagine, is going to really be the meat of this, where you all are going to be interested, and certainly that was the case in my prior ones.
And one sub-question to that, how many are SEC registered and how many are state registered investment advisors? So SEC, a few, okay, and the state would be the others. Okay.
So primarily a state crowd. Part 5 is reserved. So under the Securities Act, Part 5 is the fraud provisions. Since this is primarily directed at regulatory functions, it doesn't really cover fraud. Part 6 is administration, which touches really on just interpretive opinions and fees that we're allowed to charge for copies. So it's rather dry and not of a whole lot of interest.
And I'll let you in on a little secret. The part numbers coincide with the Act's various articles or sections. So if you trace back a rule, want to see what it ties to, that's your first clue, is that Part 1 deals with that part of the Act.
All right, so diving in, I like to call rule number 1, or 451.1.1, alphabet soup. It identifies what's CRD, what's NASA, what's a U5, ADV, BD, U4, U6, U7, NASDAQ, score, all of the various terms that being in the industry you likely already know, but they're used throughout the Act, so we define them there. 451.1.2 is a little more fun. It's a Michigan unique rule because it's a Michigan unique statutory term. This was actually drafted by me and one of the other managers in our office who's also an attorney. We spent a lot of time on it. We went back and forth with the State Bar's Business Law Section Securities Committee on it. We feel like we landed in a nice middle ground. I don't know if Shane would agree with that, but he was very involved in the way that this came about too, and I know that he's written some articles on the topic and has a lot of color to add. So without that, I'll let him take it away.
Okay, well, let me just add, the State Bar of Michigan's Business Law Section has a securities committee, and we created a working group. And I'm really pleased. We worked very closely, gave lots of comments to the Bureau, and I think in 3 iterations, worked our way through. And I think we reached a good compromise on all of the issues. Some of the issues are national issues, and on this one in particular, finders. It's a topic that, let me start with the headline. There is no federal exemption from broker-dealer registration for someone acting as a finder. People say it's a gray area. It is not a gray area. The SEC could not be clearer that if you are acting as a finder in an interstate, cross the state line transaction, you would be required to register with the SEC and become a FINRA member or registered with a FINRA member as an individual to act as a finder. You'll hear us talk about the so-called Paul Anka no action letter. Well, I'll give you a little color to that. Paul Anka, a singer, which only a few in the room will remember, basically got a no action letter from the SEC that said he could share his Rolodex with the Ottawa Senators hockey team that, dating this, was then in formation. And the SEC said that if you just give your Rolodex and don't participate in the transaction whatsoever, can't talk, here's your Rolodex, then the SEC would allow Mr. Anka to receive compensation on every introduced client that came to the Ottawa Senators. One other little rest of the story, guess what? Ottawa Senators raised zero money out of this no action letter. There is no extrapolation from that no action letter. No action letters are specific sets of facts, and I've sat on a panel at the SEC headquarters with SEC staff. If they had to ask and answer that question again, they would not have issued this because it's created too much confusion. So here's the statutory and then the rule, and I'll kind of point out this only works in Michigan because it's a statutory provision in Michigan, and it's based on, again, avoiding, the federal has an exemption for intrastate brokerage activity. So that's the federal exemption as long as it's intrastate. So within Michigan, a finder, and this is in the statute, means a person who, for consideration, participates in the offer to sell, sale, or purchase of securities by locating, introducing, or referring potential purchasers and sellers. That's it. So there was a Court of Appeals case a few years ago called Pransky, and we've written an article about it in the Michigan Bar Journal, where the Court of Appeals analyzed that definition and concluded that, oops, the legislature forgot to include any kind of registration requirement. So if you limit yourself under the statute, as construed by this Pransky case, to introducing, referring, or locating, that's it. Can't talk about it. It's just that Harry, meet Joe, Joe, meet Harry. Now pay me something. So that's the concept. Helpfully, the Bureau, in crafting a little more color around this, created a safe harbor, and that's in the rules. But it too, it's limited by the statute, is someone whose participation is limited to introducing. In addition, to qualify for the safe harbor, it has to be an accredited investor. It's not just mom and pop or grandma and grandpa. It's got to be an accredited investor. And then it's tied to the intrastate. It's got to be a resident of this state and an issuer in this state. And that's essentially the extent of the involvement as permitted under the rule. So it is capped under the safe harbor at $15 million in a 12-month period, I'm thinking. But can't negotiate, can't advise, can't talk about it, can't do due diligence on it, and basically can't participate in the drafting of private placement memorandums or anything like that. Strictly an introduction. Cannot handle the money. So when Harry meets Joe, the money has to go to the issuer. It can't go to the finder. And it cannot be transaction-based compensation. Tie this back to the SEC. The SEC's view is if you get a commission for making any part of a securities transaction happen, transaction-based compensation is a hallmark of broker-dealer activity. And so the Bureau is really tracking with that here. And so you could get a finder's fee, but it basically needs to be a fixed amount, really, and that is not tied to the outcome of the transaction and shouldn't be tied to the amount involved. So this is where there's a little push and pull, because as a practitioner, a lot of us would say this isn't going to be real helpful to issuers raising capital. But in the broader context, this is a great step forward because it recognizes the concept, and Michigan is a leader on this. A few other states, Texas has a rule, California has a rule. Again, it has to be intrastate for that to work because otherwise you get the federal prohibition. But Michigan has been a leader in the development of that. So.
And one of the things that we did was we looked at the California statutory regime on this because we found it really helpful. And I think a couple things I want to hit on is just because you don't meet this rule doesn't mean you can't be a finder. So it includes if you do fall within the definition of finder, you're exempt. But then part two of it is really trying to build a bridge to what we as a staff would recommend to our administrator is very clearly not a broker-dealer. So it's trying to take it to the farthest extreme that we saw possible, that if you do this, you're not a broker-dealer. And I think part two of that then, as far as the no transaction-based compensation, is even though that's not necessarily tied to federal law, or we're not tied to federal law, one of the things that we strive to do is to be consistent with what the federal law covers and how the SEC interprets things. So to the extent you fall within a definition federally, we want to interpret our statute the exact same way that they do, just for consistency's sake. And we try to do that across the states with NASA. So, anyways, we probably hit that way too hard. Oh, no, please, question.
For RIAs, is the solicitor's rule overlap this at all, or is that a very unrelated topic?
So that's, I'd say it's unrelated, but it's related in theory, but not in practice with this. It's the same kind of idea, but on the this is on the broker-dealer side, whereas the solicitor would be on the IA side. And that was a huge topic of discussion for their group and our group in the promulgation of the rules. We did try to come up with a version of a rule that we just couldn't find a workable way to do it at this point. That's not to say we won't, and we've had conversations with the State Bar about that. I know that Shane has been actively engaged with the North American Securities Administrators Association to develop a NASA model rule that will be workable. And I'm actually on the project group that's working on that, so we've been talking for several years about how to create a regime that makes sense, from a practical perspective and from a regulator's perspective. It's in the works, I would say, is probably the best way to put it.
And so let me use that as an opportunity to clarify a very different purpose. Solicitors are soliciting for the offer and sale of investment advisory services, opening an advisory account, not for selling securities. Selling securities is a brokerage activity, and so we like to say that's the finder. It's not. In Michigan, it's handy. There's a statutory definition of a finder, not in a lot of other states. On the solicitor side, that is for investment advisory services only. So that's the partition, and so a registered investment advisor cannot get paid for soliciting an investment in a private fund, for example. You can't get transaction-based compensation soliciting for some private fund advisor or issuer to invest in their fund. Because, bear in mind, the fund is the client in that context, and what the investor is, they're not buying investment advisory services. They're buying an investment in a fund. They're purchasing securities. So that's the difference between the two. It's a great question.
We have a question back here. Yeah, so I was just looking for some working examples. If I have somebody go out and introduce my firm to a group of individuals, I can compensate that person for the introduction of potential clients to my firm. I'm just looking for some working examples here.
So are you an investment advisor?
I'm a registered investment advisor. I'm also a broker-dealer, but I'm giving up my license. I'm kind of getting out of the commission-based stuff.
So within the definition of investment advisor representative, it includes solicit for compensation. So to the extent that somebody solicits for your firm to refer clients and you compensate them, that person would then fall within the definition of investment advisor representative. And they would have to then either be registered or exempt from registration. Sorry.
Yeah, it means they have to probably take the Series 65, and you register them with your firm because they're soliciting for you, with the exception being if they are in the business and registered with another investment advisor, or they are a registered investment advisor, then that registration covers them. But if they're not otherwise registered and someone you're paying for referring clients to you, and this varies by state, and the SEC doesn't regulate individual investment advisor representatives. They don't register them, so this is a state level issue. But you would need to register that individual with your firm even if they're not your W-2 employee. They're just a 1099 type independent contractor. And they do a U4, and you file it, and they become registered with you.
So yeah, that does fall within the definition, and it's one of those things where there are certain cases where it may not make sense for that person to have to register. It seems rather draconian, right? If you give someone a $20 gift card once a year because they gave you a client, it may not necessarily have been the intent of the legislature. We don't know that, but it falls within the definition. So without any clarity, to us, that's a violation of the law, and we're then obligated to look at whether or not we have to take administrative action for it. That, I guess, is the purpose of why attorneys on the private sector side are working with regulators to try to figure out some kind of middle ground solution where if it's the occasional thing, you may not have to register in the future if we can get that kind of rule in place. But if it's something that you're doing this professionally and pulling in 6 figures a year by referring clients, which does happen, then you're probably gonna have to register. It makes sense for you to do it. You're doing it as a business. So it's a middle ground that's there that we recognize exists, and we're working on it. I can't promise a solution, but I can promise we're working on it.
And I'll just add, to try to make sense of all of this, the purpose behind the registration and regulation of this is so that bad people who've been kicked out of the industry can't indirectly stay getting compensation by not being registered, which perhaps they can't get registered because of bad acts in their past. So it's not different from pretty much any professional regulation of any profession. Lawyers can't share our legal fees with non-lawyers. And it's meant to prevent the back door from letting bad people continue to get paid for what they've been prohibited from doing.
So any revenue sharing, your last comment ties into my second part of the question, revenue sharing with other professional groups in my center of influence, such as attorneys or tax preparers, that sort of thing. They would have to have a U4, be registered, that sort of thing too.
Yes,
Okay.
and this is one of the things that we're trying to work through. Quite commonly, that referral arrangement is not with the individual lawyer or the CPA, it's with the CPA firm. And only individuals can get registered on a U4, leaving open the question of, well, we're paying the referral compensation to the CPA firm. And most states would take the view that advice about an advisor, which is to say soliciting, to give advice about you should hire these people, would view that as falling within the definition of an investment advisor, and so the corporation or entity or a subsidiary probably needs to be itself registered as an investment advisor, limited to just that activity, but in order to receive regulated compensation, either the individual gets it and gets registered with you, or that entity itself or an entity that it's affiliated with registers as an investment advisor.
Okay, thank you. And not to split hairs, but let me give you one last scenario.
Sure.
I leave my business cards with a tax preparer. They're preparing taxes. The client has a question about some securities. Hey, give this guy a call.
Totally fine as long as it's not compensated. Because
Okay.
the whole regulatory framework kicks in around, are you engaged in the business? And compensation is, yeah, you're engaged in the business.
Yeah,
So if it's a soft relationship of cross-referral, that's not seen as compensation, that sort of thing?
No, not generally, although you're a fiduciary as an investment advisor. And so if you have really a very, let's say an elaborate relationship, even though no compensation is passed, you might have a conflict of interest that you need to disclose to the client that says, client, we have a long-term relationship with the CPA firm. We refer business to them, they refer business to us, and it's a significant amount of business. Essentially, it's a conflict of interest. And as a fiduciary, you need to disclose that to the client because you're incented to make that referral. Client should understand that accepting the referral you're making, or they're making, is it may be incented by this relationship, even if it's not. So maybe they don't have to be registered because they're not in the business. but there is a disclosure around the conflict of interest.
Shane, two quick questions for you. Back to the finder registration. Is there a, how do you address snowbirds, things like that? Is there a de minimis on the federal exemption?
There
at
is
all?
not.
Okay. Second question, since you, it was brought up, the solicitor question. Can you address the IAR registration requirement as it pertains to a solicitor, an individual solicitor for an SEC-registered firm, since the definition of an IAR is different for an SEC firm versus a state firm?
Yeah, so great question. So there is interstate, if someone's in Florida and you're in Michigan, that's interstate, that doesn't qualify for this. You could wait till they come home from Florida and do this all in Michigan, physically in Michigan. There's no interstate or de minimis exception. Federally or under the state rule, it's the safe harbor, I should say. The case in the statute would not be so specific. On the solicitor, so, going back to the CPA firm as an example, the SEC's definition of an investment advisor representative assumes that the individual is a supervised person. And so there are some federal preemption around someone who works for a regular SEC-registered and regulated investment advisor. But the SEC has made it very clear in their adopting release defining investment advisor representative and specifically addressing solicitors that states are totally permitted to regulate third-party solicitors like a CPA firm because they are not supervised by the SEC-registered investment advisor. In fact, the SEC solicitor's rule has only a nominal obligation to make sure that the solicitor is acting consistently with their solicitor's agreement. And the SEC doesn't regulate individuals, but says the states can. So in all 50 states, there are some exceptions in some states, but the key for the understanding of your question is that a third-party solicitor who is not a supervised person with the SEC-registered investment advisor is not within the SEC's definition, and so can be regulated by the states and is.
And we have. So, yeah, it's all going to depend on looking at, as you know, the definition of investment advisor representative, which can get convoluted towards the bottom of it, as you well know, right, Chad? But to the extent that you fall within that definition, you're engaged in these activities and you're collecting money, you fall within the definition, and under Section 404, you've got to be registered or exempt. So.
And if anyone wants it, we wrote a white paper in draft form because we wanted to get feedback from our American Bar Association Securities Committee members. We've gotten no feedback. So it'll be final as written, and I'm happy to send it to anybody who would like it, because it really goes through a lot of the in-the-weeds kind of issues that, you know, things just don't quite work real well, and ultimately the goal, public policy, is we want to connect investors with professional advisors because people don't save enough and they don't save it soon enough. And we really want to make sure we can find a way to effectively refer CPA firms or lawyers to refer clients and business to registered and regulated people because they really do need the advice. So we want to try to make it clear how that all works.
And after these seminars, Heather Miller always sends an email out with both a survey and documents that we discuss. So I'm imagining we could have that as an attachment to it. So
Yep, sounds good.
I guess we're all ready to move on. Who's excited for some exemptions from registration for securities products? Most of the room, I mean, just based on what the hands were when we were talking about I's and BDs, aren't going to care a whole lot about statements of policies, recognized securities manuals, and bad actor disqualification from specific exemptions under Article 2. I will touch on, this is one of the examples where having private industry comment to us on our rules really reined us in as regulators a little bit where we needed it. We had a broad bad actor disqualification from any exemption under Article 2 drafted and ready to be implemented until we had the business law section point out to us that it would pretty much destroy the ability of most mutual funds to operate in the state of Michigan, which was not what we were going for. So we really reined it in, tailored it down and have it apply to just a few exemptions. What do I have up there? Bad actor disqualification. So that was that one. Again, not a huge deal. The oil and gas exemption, same thing. It exists in the transition orders, nothing new. Clarifying the meaning of purchaser under Rule 2.5 for purposes of 2021N, which is a limited offering exemption to the extent that the offering is to 50 or fewer purchases, there's no transaction-based compensation, and there's no general solicitation. Then you got an exemption. This clarifies purchaser to include, basically a household. So that was another helpful suggestion from the business law section.
I'll add one note to that, and that is Michigan has, for securities offerings, an exceptionally broad 50 purchasers. Most, if you're not under SEC rule, Reg D, Rule 506, so it's a federal covered security and hence preempt state law, if it's not under that exemption, most states are not as generous with this, the permissible number of investors. So.
Yeah, and I want to say it was 2014 that we expanded that number from 25, I believe. I think it was 10 in the old act, 25 in the initial Uniform Securities Act, and in 2014 it went to 50. And that was a business law section boot camp a few years ago, and the presentation that was being given still said 25, and it's, no, it's 50 now. It's 50. Neither here nor there. Moving on. So securities registration and notice filings, again, we're talking about securities product, which really isn't the room here, but creates a notice filing as far as Form Ds for 506 offerings, et cetera. 3.2 designates the EFD, which, Linda, do you want to hit on the EFD at all, or just do it? No. Okay. Yeah, that's true. We'll try to move on a little bit. But EFD is going to collect filings for Form Ds and for mutual funds, I believe, going forward. Effective. UIT is also? Okay. So instead of an issuer having to file with all 50 states individually, they can file in one place. It really, really makes it more efficient to do a nationwide securities offering, and NASA's been pushing this and really trying to make the industry more efficient from that perspective. The small corporate offering exemption, we try to track with the Rule 504 exemption and the new bump from 1 million to 5 million. So this kind of pairs well with that. 3.4 is prospectus requirements. 3.5 requirements for issuers who register by qualification. Statements of policy for other securities offerings, and 3.6. I'm guessing there's no questions on the product. Seeing no hands, we move on. 3.7 is to make Heather Miller's life easier to the extent that a product sits and becomes stale. This allows her to dispose of it without having to go through a song and dance. So 3.7 just makes the administrator's life and her staff's life a little bit easier. All right, on to Article 4, which I think is really the meat for everybody here. The Canadian exemption for broker-dealers and agents, it's really the same thing as Transition Order 5, Paragraph 3 that's currently in place. There's not going to be any change from this. This one is another one where we're going to hear a lot from Shane. He, again, has been very involved with NASA on this and creating a model rule that's been adopted in a number of jurisdictions. And in addition to the state level, he's also been working through the National Bar Association, the ABA, to get Congress to adopt a federal version of this to really mirror it and pair with it for mergers and acquisitions brokers. So with that, I'll let Shane kind of touch on it a little bit.
Well, given the audience, I won't spend a ton of time on this, just to tell you what the problem is and what we're working on as the solution. The problem is if you're a business broker and you sell the local manufacturing business or a bookstore down the street, and you sell the assets for cash, there's probably not a security involved, and you probably have to have a real estate license to do that because it's usually real estate, either brick and mortar or dirt or a lease involved. But if you sell the equity of the entity that owns that, if it's a corporation, you are now selling stock. Stock's a security. You're now a stockbroker. You're regulated like Merrill Lynch, an investment banking firm, to sell the local bookstore. Makes no sense at all. Near and dear to my heart, because I wrote the federal legislation and Congressman Huizenga introduced it, and it has now no less than twice unanimously passed the U.S. House of Representatives, and no less than 6 years of Congress, the Senate Banking Committee has not taken it up. Last session, it was in 4 different bill packages that at the end of the year they could have passed in one way or another, including Jobs Act 3.0, and the Senate Banking Committee did nothing with it. We're hopeful that it will pass, but it has not yet. Good news is this whole effort has resulted in an SEC no action letter. It's a no action letter. It doesn't bind the commission. It doesn't bind anybody. But if you, for private companies, and you are basically brokering the sale of someone who's actively running it to someone who's going to actively run it, then that's really not typical brokerage, and the SEC has issued a no action letter. There's like 10 conditions to meet, but basically helps business brokers for now. And NASA baked the federal legislation into a model rule. So, and Michigan is adopting it. And so we're hopeful that we can get the federal legislation to catch up with this.
I
Judith?
was just wondering if you knew off the top of your head the name or number of that no action letter.
Yes, it's the Merger and Acquisition Brokers, and I can send it to you. We could include it in the materials that go out, but if you Google M&A, M&A brokers, and it's unlike a typical no action letter because it's addressed to the industry. It's not addressed, it's 6 lawyers who happen to be my friends. And
Really nice guys, too.
yeah, so really broad in its scope, but it's only a no action letter, and that's what we keep telling Congress. It's like, you got to change the law to make this work. So there's not a lot of M&A folks in here, but understand that in the context of a client selling a business, it's permissible to hire somebody who is not a SEC-registered FINRA member, Wall Street investment banker. So.
All right, so we had a lot of slides on that. It really just goes through the elements of how you comply with it. Shane covered it pretty well. 4.3, it appoints the CRD and the IARD respectively as depository filing locations for broker-dealers, agents, investment advisors, IARs, and federal covered investment advisors. There's no change in policy here. You know, you're going to file your U4, your ADV, et cetera, the exact same way after July 3rd as you did before. There's no change here at all. 4.4 allows for the use of electronic signatures and transactions that occur within the scope of the act. This really is just meant to track with UEDA. It allows for it, it doesn't require it. It's really, I think, geared more towards the product space again to allow for electronic transactions to happen. This one is
And I would just add, Steve, on it, because it is becoming very prevalent to sign electronic signatures to product applications to buy something, some investment product. The federal e-sign act and there's a state equivalent act both recognize that if you jump through the right hoops, which is essentially that the person who's signing knows what they're doing and takes some affirmative action like click through and therefore manifest their agreement, and you record it, you have to be able to reproduce the result. And the rules, in some painful detail, kind of go through some of that. And so it is permissible. A couple of things to highlight about that is that there's always a risk of fraud when things are not, we think manually signed, but I can tell you historically, people forge signatures. Go figure. That happens. So you got to be careful if you're in the role of relying on an electronic signature that it hasn't been forged by somebody, because you don't really see who is at the other end of the computer clicking on things. There are some great software programs called like DocuSign. There's a few others that have protocols that really enhance the reliability of that. So.
And just, for me, from a regulators and in particular an enforcement perspective, this is not something that's been on our radar at all. It's, I think, going to be a helpful rule that it's going to make it more allowable for things that are already happening. It's just not something that we're really all that worried about it because it's reality, right? Like, we live in an electronic world primarily. So another one, and 4.5 actually represents a huge policy shift for Michigan on a moving forward basis. Again, this is the one rule that's going to take effect in January of 2020 as opposed to in July. And we'll get into that a little bit in the reasoning for the 12-month period as opposed to the 6-month. But it's a private fund advisor exemption. Currently, under Transition Order 6, to the extent that the advisor has a contract, a written contract with the fund, which is typically going to be the same person for each, and only accepts accredited investors as investors or beneficial owners of the fund, they can be exempt from registration. A number of years ago, NASA put out a model rule on this that most of the states around us that have the same statutory scheme have adopted. You know, I think about Wisconsin, I think about Indiana, I think about Minnesota. You know, there's a lot of Midwest 2002 Uniform Securities Act states have adopted some version of this, and we've adopted what was really a negotiated thing between us that I think represents a nice business-friendly but still investor protection-oriented rule that's tougher than Transition Order 6, but less onerous than the NASA model rule and a little more forgiving as far as who's allowed to invest. Again, Shane, I think, could add a little more color, and we've got some slides that add it. Please.
Sure. Well, I'll just add a little bigger context to how this makes sense. So back in the Dodd-Frank Act, following the national financial crisis, the SEC and Congress figured out that what used to be a private, they call it the private advisor exemption, it meant federally you could have up to 15 clients before you had to register, and states had that similar, and they still, most states still do have something like that. And they concluded that we need to understand what all, because each fund is itself a client. No matter how many investors it has, the fund is the client. So a fund advisor could have up to 15 funds and not have to be SEC registered. Congress said, time out, we need to know what's going on in a huge black sector of the economy. We don't know what's going on. So they repealed that, and so federally there is not that private advisor exemption. And so to counteract that, they created two exemptions by SEC, congressional action and SEC rule to implement a venture capital fund exception. Venture capital funds are basically investing in startup companies. They are pretty well defined. It's not something that you would use for any other purpose than like an angel investor group with startup companies. That's a venture capital fund. It has its own little set of rules. And then private funds, which advisors have said, if you're forming a fund, getting investors in your fund, the fund is the client and the investors are beneficial owners. And what both Congress and now in the states, in the transition order up until now, has created an exemption from registration as an investment advisor if your only clients are private funds. And there's actually no limit on it. The SEC has a dollar cap. If you hit 150 million in total funds, then you'd have to register with the SEC as an investment advisor. And so that's kind of the context for this. So if you're registered already, you don't need to rely on this. But there's a flip side to that coin. If you, as a registered investment advisor, are advising a fund, you have the power of the pen over the fund, what it buys, what it sells. You have custody of the fund. And Steve will talk about the custody rule, but part of that is having to have audited financial statements for the fund. And the contention, or the tension, not contention, tension
It was a little contentious at times.
that we had for this private fund advisor exemption, and it's just if you are not registered and you want to be exempt from registration, your only clients are private funds, it's essentially the equivalent, though. You control that fund and its assets, and so there's an audited financial statement requirement for private fund advisors in order to stay exempt from registration. And of course, if you register, then you have to have the audited financial statements anyway. So the whole idea is to protect investors in a private fund, and so that's the broad framework for this. So are there any unregistered private fund advisors in the room? No, okay, so this largely won't affect you, but it may give you some background for due diligence if someone walks in the door to say, hey, I have a private fund I'd like your clients to invest in. So you as a fiduciary need to do due diligence on what are they selling, and are they in compliance with the law with respect to their offering of securities in the fund, and their compliance with either registration or exemption from investment advisor status.
Since the audience probably doesn't have a whole lot of care for this, take a look at the rule, like Shane was saying, to the extent that you have somebody approach you about this. Understand the difference between funds that accept accredited investors versus funds that only have qualified clients. They have different obligations as far as what they're obligated to report to their clients. Touched on the delayed effectiveness, and we can kind of move forward from there. For the federal covered IAs, notice filing, it's the exact same thing as it is under Transition Order 1. We're just putting it into rule form. Continue to file through CRD, IARD. 4.7, application for registration by broker-dealers and agents. Again, this is all exactly the same with one important distinction, updating. So with updating currently, there's no time period put on when you have to update your registration documents to reflect a change in it. It's just, within a reasonable time, I think, or what's the exact phrasing in the statute, can you remember? It's promptly. Promptly is the word. So what's promptly mean? To some people it might mean tomorrow, to some people it might mean next month, might mean quarterly. It's really not a good defined time period. So within all of our rules for our updates, we changed that to add a hard cap, which is within 30 days of the event requiring the amendment. So say you get a tax lien, right? Within 30 days of getting that tax lien, you need to update your U4, just as an example. So that's one change that's not only applicable with broker-dealers, but then also with IAs.
And I'll just add, it's a broad, so compromise with creditors. So let's say you can't pay your credit card bill and you cut a deal with your credit card company. That's a compromise with creditors. It becomes a U4 reporting item. And I can tell you, in the broker-dealer world, FINRA goes out and actually has a cottage industry of looking for liens, state and federal tax liens and things like that. So don't let things go, because they'll come back to bite you. Chad?
Yeah, Stephen mentioned it was applicable for investment advisors as well, is that correct?
Yes, so once we get to the IA
Okay.
actual rules of the filing rule.
So are you talking about all changes or material changes? Because that would
So
be
material change.
contrary to the instructions in an ADV form.
Yeah, no, exactly. So to the extent you have a material change that you would have to update, that's when it would be. Yeah,
Okay, so it doesn't apply to non-material changes on.
yeah, correct.
Thank you.
So you'd still have your annual updating amendments that you have to do routinely. It's to the extent you have an enforcement action, you need to update that to reflect it. If you have a tax lien filed, if you have, like Shane was saying, compromise with creditors. Just going through and identifying the various reporting items that you have, to the extent it's gonna be a disclosure on your broker check, or on whatever it's gonna be, it's gonna be reportable within 30 days of the event. And that's primarily as an investor protection. We want investors in Michigan to understand who they're dealing with, what they're dealing with, and whether or not somebody's got an event that, at this point, the SEC or FINRA has deemed to be reportable. So that's really the reasoning behind it. 4.8 is application by Michigan investment markets. This is another kind of funky Michigan unique thing that we have that other states don't have. The Michigan investment markets, and I know Shane was also involved with the legislature when this one went through.
On the other side, I actually testified to say there is no intrastate for exemption for exchanges. Yeah. Securities or stock exchanges are regulated by the SEC no matter what. And the concept of a local exchange, which seemed to be someone's good idea, requires registration with the SEC as either an exchange or under regulation ATS, alternate trading system, as a broker-dealer.
So one of the things that we did with this is we essentially, because the idea is it's going to be a broker-dealer, we took the broker-dealer application and the requirements there, we put that in the rule, and then added proof of compliance with the 1934 Act. So if you can get something like an SEC no action letter to say, no, you don't have to register as an exchange, good for you. So we've had one inquiry on this when we sent them the list of things they needed to provide, including proof of compliance with the Exchange Act. We haven't heard back yet, but I'm really curious to see if it'll work. I genuinely am.
Concept's good.
It's a
I mean,
great
getting a
concept,
secondary
it is.
market for private placements is kind of what the motivation was.
Anytime
Or
you can have-
crowd-funded securities.
Anytime you can have liquidity in a market, it's a good thing, right? So to the extent that you can, from a federal perspective, get this to work, I think it's a great idea. But the last thing that we as a state regulator want is to have somebody walk in, comply with our rule, our law, and then have the feds knocking on the door saying, give it all back with interest. So that's what we're trying to avoid in having that requirement. And I think it comes off as, we're trying to overregulate, but it's the exact opposite. We're trying to protect you from having the SEC knock your door down, which they wouldn't do, I guess, but having them come at you and give you an enforcement action. So that's the Michigan investment market. Broker-dealer and agent examination requirements, not much of a change from a state perspective. I know everyone's aware of the SIE. That's covered within this because the NASA model rule says any other examination required by FINRA. So
SIE being?
I can't even remember what the acronym is for. There's too many now, but it's the new agent exam, right?
Yes.
So you've got to pass that before you can take your.
It's the entry-level exam FINRA developed, which you could take as a college student coming out while you're in college. You don't have to be sponsored by a broker-dealer to take it.
So yeah, no changes here. Again, to the extent that FINRA requires something new, you got to take it. That's really all there is. Any other questions? I know I've kind of been running through these now. Good, okay. Application for registration by investment advisors, to circle back to what we were talking about a little bit ago on the broker-dealer side. It's all exactly the same. You file the same way as you have, with the exception of the 30-day time period for material changes. So to the extent that you've got something that requires you to amend your registration documents, it's got to be within 30 days of the event. I guess I'm going to circle back to that. The filing of a bond is one that we'll touch on a little bit because I know we got questions at our prior two seminars, and we'll jump to it because there is a rule specific to it. But to the extent that you're required to file a bond, you've got to have that with the administrator as well with your registration. Registration by IARs, again, same thing, 30-day time period, nothing new. And IAR exam requirements, 65 combined 766. If you're registered in the same state with the same registration and exam requirements within 2 years, immediately preceding the filing, you don't have to retake. We also continue the Transition Order 1 designation exemption from the exam. I don't think this is terribly controversial. Custody, under Transition Order 6, currently we just point to the SEC rule, be in compliance with it.
This one bears some discussion, though, because I'll just emphasize, and we got a question up there. Custody is not just, I've got it in my hand. Custody is the power of the pen, that you have the power to move money. So bill-paying services, you think you're doing the client a great service, they go to Florida, they're a snowbird, they want you to pay their bills while you're gone. So they give you their checkbook. You have custody of the assets in that account. And under the custody rule, SEC and state, and now baked into Michigan's rules, you have to have a surprise inspection from a third-party CPA firm at least once a year. It's not an audit, it's an agreed-upon procedure where they come in and check the flow of money. Is all the money where it's supposed to be as of a surprise date that the CPAs pick. And they have to file a Form ADVE via electronically, and you guys it'd be filed for you for state-registered investment advisors. So what you need to think about is not just physically a check comes in, or cash, heaven forbid cash, but a check comes in, you can't deposit it to your account. And if you have the power of the pen, And the difference is between trading authority, where you're moving it between the client's accounts. That's fine. The SEC has some concerns around custody with standing letters of authority, and that's probably too much of an issue to get into now. I'm happy to talk about it later. But think through, if you have the ability to withdraw money or move it or issue checks, you're going to have custody. It's constructive custody, and it's going to trigger these requirements. So you probably have to tell the client, A, it's going to cost the firm $10,000, $12,000 every year to have this surprise inspection performed, or I can't do that service for you. I'm sorry.
Couple comments or questions as well, and probably more for Stephen than Shane, but I wouldn't mind hearing Shane's comments as well. Well, I certainly appreciate the uniformity in following the SEC custody rule. There are certain elements of the rule that do not follow the SEC custody rule as far as processing of unrelated third-party checks within 24 hours. That doesn't show up in the SEC rule, and it's even contrary to NASA model rule, which gives us 72 hours. So there is some black and white where at least it's in there in front of an advisor, so we know what we have to do. An advisor would know what they have to do. However, there's also elements of states that follow the SEC custody rule that aren't real clear on whether or not they follow SEC guidance in some of the gray areas, such as acting as trustee for family and friends, the SLOA issue, standing letters of authorization, which the SEC issued interpretive guidance on a couple years ago. Very few states, to my knowledge, have actually issued guidance on whether or not they follow the SEC's guidance, even though they will follow the SEC custody rule. Ohio, for instance, does in fact follow SEC guidance. Other states don't follow SEC guidance. Given the fact that Michigan does follow the SEC custody rule, is there any assurance that you can give or comments you can give regarding the gray areas of those SEC guidance on issues such as trustee for family and friends, is that custody, on following the 7-step protocol for SLOA and things of that nature?
So just given the fact that I'm a lawyer, I never like to give assurances on anything. But that being said, I guess, to be serious, I can't give any assurances because at the end of the day, it's not my decision on any of these, right? I make recommendations to the administrator who is gonna have the full breadth of these are the options. This is the universe you're working in. What do you want to do? I get to make recommendations in this space, right? So my recommendation in just about any circumstance, especially when it comes to the custody rule, is this is what the SEC does. This is what we should do for consistency's sake. That goes with direct fee deduction. It goes with SLOAs. It goes with the family friends thing. To the extent the SEC would allow it, from my perspective, we should. That's my general take on it. So long as we have the exact same general roads we're going down. So that would be my recommendation generally. Whether or not that's what my boss decides, I can't tell you. But just as a general rule, I like to be consistent as best I can.
And I'll just add to that, the standing letters of authority, or SLOAs, as well as inadvertent custody, are issues that have continued to evolve at the SEC. I think the standing letters of authority are a little clearer now than they were. The SEC has guidance you can find on their website. The inadvertent custody issue is where your client perhaps comes to you with a custodial agreement, a brokerage account agreement, that embedded in there gives you as the investment advisor, the client's representative or agent, authority to do virtually anything. And it's because the custodian wants to protect their behind by relying on whatever you tell them to do. Because if you tell them to do something that you weren't authorized to do by the client, well, there's this language in the custodial agreement that protects them. And this is evolving slowly because the SEC has basically called these custodians to task for these overly broad authorizations in their custodial agreements that you might not have any knowledge of, but the authority is there nonetheless and can be abused. That's, of course, the concern. So a takeaway from this would be to go back and give consideration to those third-party agreements, custodial agreements, that might have language that gives you that power of the pen to give orders that would give you custody over that account. And this is something the SEC has acknowledged is an industry-wide issue. They've given some guidance on it, and they've been working with the big custodial players, Pershing, Schwab, you know, the big custodians, to try to fix that problem.
And I think one of the other things that just talking to whether it's administrators, examiners, other enforcement attorneys from around the country, that we're seeing a lot in this context, and I know that our examiners could probably tell you the same thing, is client usernames and passwords. So to the extent that you take a client's individual usernames and passwords to, you know, their 401k account because you want to advise them on it, you could log into that account and direct a check to yourself. That's custody. So even though what you're trying to do is to advise your client on the whole swath of assets that they have, to the extent that you're able to get into their account that way, if you don't have an individual third-party read-only way to view it, it's custody.
I'll just add a little color that in a pension plan, the participant typically cannot cause a withdrawal. It has to be approved by the trustee of the plan or the plan administrator. And so it's a little nuanced, because I agree with Steve, that again, it's the power of the pen, electronic pen. But in some circumstances, the pension plan simply doesn't, and they're set up, the record keeper, TPA, doesn't allow a withdrawal unless it goes through a process. So, so there's a little gray area there that could be talked about. I think we got a question up and back.
Yeah.
Yeah, I'd just like to clarify that. So my understanding is if you go into the client portal using their username and password, as long as you're not able to take a loan or move any money in that capacity, then it is okay? Am I incorrect? I know it's a gray area, but as long as you can't move money through the client's credentials, we can.
Impersonating them. Yeah, and I
You
would
say committing fraud?
So I would phrase it as you're impersonating them at that point in the eyes of that account.
What happens if it's in conjunction with the client?
Even if it's in conjunction with the client, like if you have a list of usernames and passwords, we're gonna frown on that. You
Okay.
shouldn't have it, that's a breach of fiduciary duty, because chances are, with that, whoever that account is with, they're gonna have something in their user agreement that to the extent you give your credentials out to whomever, any third party, they're dispelled of any kind of fraud liability, of any kind of liability to you if something happens in the account, regardless. More often than not, that's the case. So having usernames and passwords is something that you're going to get dinged on an exam by one of your examiners. That's just the way it is. If you can get third-party access, that's your own username and password to whatever that portal is, which I know a lot of custodians are starting to do, that's fine. But if you're using the clients, that's a huge no-no. And NASA recently put out a white paper on this that discusses a lot of the legal issues that come along with it, including the potential that you could be ruining your clients' protections under that account. So there's a lot of gray area here, but from our perspective as a regulator, chances are you're breaching your fiduciary duty to them, and we're not going to look kindly on it. Yeah, up in the corner. Do you have a mic by chance? Jason, mic. Up top.
Do you mind if I just speak to
Yeah,
that
go for it.
topic?
We got
For
one
an
down here
example
quick
of why a potential issue would raise, like changing the email address on file for that client logging in?
Changing an email address.
Then but
if
I'm
you-
saying DocuSign, you could
Yeah.
issue it to your own email and have full discretion of
Yeah.
what happens. So there's reasons why.
There are
You
a
wouldn't
lot of
want full
reasons you
access.
should not have it. Yeah, that's a very good point. Thank you.
And it may violate the terms of the retirement plan.
Yeah.
Because bear in mind, even though we like to think of the funds in the retirement participants account as theirs, it's really not. It's the trust that is the plan, and the plan has a whole bunch of parameters around access and use and whatnot. It's definitely a thorny area because you're trying to do good client service, but the client may not understand that they're not permitted to give out their user ID and password. And so, yeah, it's a tough issue.
Yeah, hard no with the SEC for sure. Yeah, up top.
Sure. So there's a number of different softwares that allow for advisors to access. So where perhaps you're custodying your assets at Charles Schwab, but you have a reporting software that's going to allow you to gain access to other held away assets. So I've spent time with those companies and asked, so how do we get the logon credentials into the software so that we can gain access to, say, a Fidelity 401k, even though the assets that we're managing are held at Charles Schwab? And many of those softwares, they don't allow the client to input the username or password. Even though once it's entered, you don't have access to it anymore. But I mean, practically speaking, you'd have to have the username and password, enter it on behalf of the client. Even though you're not directly accessing it, you're providing it to that third party. So is even accessing or having the password, even if you're not using it in the way that was described previously, but just facilitating that to that software, going to create a custody issue?
So if you have access to the account, if you have the username, you have the password, you have, like Shane was describing, the power of the pen. Even if you're not using it for that, you have it, and that would be an issue.
What if you're not maintaining it, though?
I mean, to the extent you don't maintain it, then you don't, right? Like if you destroy it and you don't have access to it, you don't have custody, yeah.
The reason I asked such a specific question is it came up in the conversation with the technology company where I was asking, so if the client can't go to a secure portal and put it in themselves, but they're asking us to supervise or have access to that account, we don't want to have the risk and liability of maintaining it, but entering it to facilitate the process seemed like it would have been reasonable. I'm just curious, so.
Well, I would add to that, I've looked at InvestNet, which is a data aggregator, and they have a procedural setup where there is an initial access that gets the information entered, but then it changes, the user ID and password. That changes, so it's a one-time and done, and but we're definitely into the weeds on this, and it's a knotty issue. And as Linda says, the SEC and the Bureau is quite clear about user ID and password. And even though lawyers might argue that there's some other protections there, the regulators haven't bought into that yet. So.
Yeah, I just have one question. I've seen in some of the 401ks and even in my own personal bank accounts, just having the login ID and password is not enough. There are security questions which you have to know the answers. So I can go into my account, I can log in, but unless I put in the answer to the security question, then I cannot really log in. Or even if I can log in, I cannot do certain transactions. So a lot of these financial institutions, so it wasn't there in the past. But in the past few years, I'm noticing these security questions and a lot of these other two-factor, they call it two-factor authentications, they're happening to make the system more secure. So I don't know whether the regulators take that into consideration.
I don't think they have yet, and I'll give you examples where that could be used, still be a risk of investor loss. So one example of two-factor authentication is that you get a text message on your phone, and whoever has possession of that phone, now maybe you have to have a thumbprint to get into the phone. There are multiple layers here, but I think that as a general rule, neither the SEC nor the state of Michigan nor other states have kind of moved off of the basic premise that there's a risk of identity theft and have not allowed it.
I may just add one more point. I think Google is, recently they released a device in which a lot of the accounts, you don't need a login ID and password in the traditional sense. That device generates a particular number for the login ID and password. And unless you have possession of that device, you cannot really go into those accounts. So technology, in my words, is leapfrogging regulation in certain cases.
This won't be the first time that has happened.
Or the last, more
or the
than
last.
likely, yeah.
Again, the fob that has, you know, the random number generator in it, whoever has possession of that, and it's not embedded in the client's hand, it can be handed off. It's still a risk, and because, as a matter of public policy, there are just so many variations on this, and the technology is moving really fast. I think that's why there has been reluctance or intransigence, depending on which perspective you have on that, to allow for exceptions to what is otherwise a pretty bright line.
I guess just moving forward to a new requirement under the rules is going to be bonding for certain investment advisors. Now, most investment advisors are not individuals, right? Most are going to be firms, and then the investment advisor rep is the individual associated with the firm. So this is applicable to the IA firm, unless it's a sole prop, in which case you've got a whole other set of issues, but bonding requirements for certain investment advisors. And this comes into play with respect to having discretionary authority and with respect to having custody. We'll talk on that in 4.417 in a minute, but it's a new requirement that is being imposed.
And just a quickie on that, what we're talking about is third-party insurance company bonding, a company that issues a fidelity bond, and these are readily available in the market, but you need to find an insurance company to.
And I want to say that Linda looked into it or tried to look into having somebody come to talk about bonds, but we weren't able to line anybody up. But I don't believe they were terribly expensive from what I recall. That being said, we'll hit on 4.15 and 4.16 real quick and then move on with a little more substance on the minimum requirements for IAs. This is the same. We can't change what the SEC and FINRA have for minimum net capital requirements for broker-dealers. We impose the same thing on the Michigan investment markets, or the MIMs as they're called. Just as I said earlier, they're essentially acting as BDs. So if you have custody, it's a $35,000 net worth. If you have discretionary authority, it's a $10,000 net worth requirement. To the extent that you don't meet that, you've got to have a bond to the nearest $5,000. I say at the bottom of my slide here to consult with counsel because different situations are different. So if you want to throw tomatoes, please throw them at Shane, but he might not help you then.
I'd add one point here, because the rule itself doesn't address, well, I don't have discretion and I don't have custody, what's my minimum financial requirement? And it doesn't actually say it in the rule, it says it in the statute. So you need to always bear in mind that when you read the rules, the statute is in, the rules and the statute have to be read together. And so you have to have a positive net worth, i.e. you can't be insolvent.
Yeah, and that was Shane and I talked on the phone the other day getting ready for this presentation, and he was like, does it say it in there anywhere? Because I didn't see it. And I thought to myself, last week I was looking through this and I thought the same thing. And why doesn't the NASA model rule cover this? And it's because the statute does. It's at section 412.4G. It's MCL 451.24124G. You got to be solvent. That's it. So having a positive net worth to the extent that you don't have either discretionary authority or custody. Financial statements, this is a new rule, but I think it's pretty common sense. Your basic CPA dictated financial statements. The default is that they're unaudited unless the administrator requires otherwise. Shane, it looked like you wanted to.
Well, I would only add to that, and actually if you want to comment, if it's audited statements have to be GAAP, generally accepted accounting principles. What's your thought here? Is this, it's not audited, but does it have to be GAAP, or quite commonly tax cash basis accounting is the alternative to GAAP?
I'm pretty sure without looking at the rule, and I haven't looked at this one in particular in a while, I think it says GAAP, but.
I think it does. I'm pretty sure it does.
Curious, let's pull it up.
So that's a nuance, because a lot of service companies, our law firm, we have over 100 partners and 8 offices, and we're a cash basis accounting system. So it would be very common for service companies to do that too. But I do think it is GAAP accounting, so.
So looking at the rule real quick, because we discussed this, I remember when we were dickering and dealing over language, and in sub-rule 4, to the extent that you want to submit a non-GAAP compliant financial statement of any sort, all you've got to do is make a request and the administrator can grant that request in her discretion. So if you submit a request to submit a non-GAAP compliant financial statement, balance sheet, for example, in connection with, solvency inquiry, as long as you make that request, we're able to grant those. It looks like there's a question up top.
Yeah, GAAP compliant financial statements are going to be accrual base. And if we're going to file accrual base and we bill our clients in advance at the beginning of the quarter, for example, we now have a liability for the entire amount of the advance fees. And that in and of itself could create an insolvency.
You're speaking Chinese to me because I'm a lawyer, not an accountant. No, I'm just kidding. So typically I depend on my boss because he's a CPA for accounting questions, but I can grasp it pretty generally. I think the idea behind this is that to the extent that you have that situation, let us know. If you have a good explanation like that for why you're not going to be complying with it, we can waive the requirement, and it's pretty easy to do.
Yeah, you're basically earning the fee over the course of the billing period, whether it's monthly or quarterly. And so you do have a liability. So one of the considerations is you don't take the cash out of the firm because you've gotten paid. So you leave the cash in the firm throughout that period, and so you have assets that offset the liabilities. And so you're not insolvent. But you do have to be careful about taking distributions or withdrawals from the firm, which would throw that otherwise accounting off. And let me add, just as that, it's a great point. If you bill in advance, be sure you have a mechanism for addressing in your disclosures how you handle refunds. If someone terminates within the advance billing period, a lot of firms have neglected that. Form ADV actually has some instructions about how to disclose it. But I say that only because it's a kind of a hot topic. It's come up recently.
Yeah. Types of fees being charged.
How do you
by-
refund
How do you refund
advance
it?
fees? Right.
We've been talking a lot about that in our project group at NASA. IA brochure, again, file it the same way you've always filed it, with the caveat that any material changes need to be filed promptly, with promptly meaning 30 days of the event. Proxy voting, it's a fraudulent, deceptive, or manipulative act for an IA to exercise voting authority of client securities unless, and it's got the laundry list. This is really just pulled from an SEC rule, which was previously applicable to state-level IAs as a record-keeping requirement. So it ideally won't be anything new.
Well, there's a sleeper issue here that I don't think we resolved ultimately, and that is record keeping related to it. The SEC rule requires, and this was developed mainly around mutual funds that vote proxies for thousands of securities and millions of investors. And the SEC wanted to get a handle on being able to analyze how people vote proxies on behalf of their clients or a fund, their client. And the SEC requires that you maintain records of how you voted on these proxies. It's a massive undertaking, and there are vendors that actually help track with that. And so in the record-keeping rule, I'm trying to remember if that was something that,
We covered that. I remember you gave us a list of the ones.
yeah, so.
So the bar gave us a list of items that you don't have to keep records on that. And it's basically the big ones that Shane's talking about that are pretty common that the SEC really wouldn't. So, yeah. Business continuity and succession planning. I've said it at all of the seminars. It's essentially, it comes down to you owe your clients a fiduciary duty to know what's going to happen if something happens to you. And it's less if and more when, because all of us have accidents. Unfortunately, all of us die. Something's going to happen to any one of us. We have weather events. I wasn't able to go to work and my laptop was stuck and I had to fly to San Diego for a work engagement. It wasn't fun. It was an unanticipated delay in my ability to do my job. I ended up having to go to my boss's boss to get security codes to get into the building, to get things I needed to go on this trip. We all have things happen, and you need to have a plan in place in case, it gets too cold to go outside, you get 10 feet of snow overnight, whatever it is. This is designed to cover that situation. It's having a plan in place that covers unplanned business interruptions and giving your clients, the peace of mind of knowing this is who's going to be there, this is how it's going to get covered, and this is how my business is going to go on in my absence.
And I have lived through examples of solo practitioners getting sick and dying, or being in accidents and dying, leaving their spouse and the staff with how do we sort this all out? Because the spouse wasn't active in the business, and there was like, how do we contact clients? And it's just something that if you think through ahead of time, you can have some written instructions for what staff should do, especially if you're a solo, to have instructions for what the staff should do, who to contact, how to access this or that or the other, user IDs and passwords that the IA firm has legitimately. How do you get into some of these accounts and things? And we live in a part of the country where the earth doesn't shake and the hurricanes don't blow by very often. But we do have tornadoes and other issues, and people do get sick and have accidents. So it is an old saying that the cobbler's children have no shoes. And you're giving advice to clients. This is advice to yourself.
Records for BDs, again, it just points to the SEC rule on the matter, just to move us forward a little bit. Records for IAs, we just touched on this a little bit. So currently the transition order points to the SEC rule on the matter. This actually gives out the full list of records that we would expect for you to keep. It's based on the NASA model rule, which lo and behold is based on the SEC rule. So it's really designed to maintain a level of consistency across state and federal law. Prohibited practices of IAs and IARs. Shane and I talked about this topic the other day too, because it currently under the Act is Section 412.4M lists its basis for us to take an action on your license if you engage in dishonest or unethical behavior. Well, what's dishonest and unethical behavior? This lays out a list of you shall nots. In addition to, this list isn't all encompassing, but it identifies the things, it's just a clear line you can't do. If you do this, we're gonna have reason to take action on a license. And Shane and I both agreed that it's nice for the industry to have to understand. Yeah, question up top.
Sorry, I wanted to ask a question on the business continuity and business succession plan.
Yeah.
Is the business succession plan a new part of that? We've always had to, as a compliance officer, have to have a business continuity plan in place, and I had read that there was possibility of the business succession plan, planning for the death or disability of key employees or sole props. So is that new?
I'd say it's a new requirement. At the end of from my perspective as a regulator, and we'll probably disagree on this, you owe that to your clients to have a plan in place, because we all know at some point we're all going to die, right? At some point we could become incapacitated or just be unable to do our job. You owe it to your clients to have some kind of plan in place that, their assets are going to be covered, or their ability to get financial advice is going to be covered.
So here's a little difference between SEC-registered investment advisors and state-registered investment advisors. The SEC's rule is business continuity, and it's under essentially their compliance rule. It does not address, the SEC's does not address succession planning. The SEC had fiddled around with a rule that never went anywhere, that would have sort of set this out as its own rule rather than being just part of the compliance program. But the states, the model rule and Michigan have actually created the rule, and they've added succession planning to it. Now, it isn't going to prescribe how you go about it or minimum requirements for it. It really is, it is there so that if the examiners, and we want to leave time for the examiners to come talk, when they come to ask, what have you done for succession planning? You have something you can produce that we've thought through these issues. Maybe not, like any kind of forward-looking plan, it's the process that's important in developing the plan, because the day after tomorrow, the plan itself will be outdated and something will happen that's different. But to have evidence that you have spent time thinking about succession, what would happen, I think that's really what the rule is driving at.
And I think in this instance, that's where we differ from the SEC, notwithstanding the fact that I keep saying we try to be consistent, in that there's a material difference between most federal IAs versus most state IAs, in that most state IAs have a smaller AUM just by definition. So a lot of times it's a 1 or 2 man shop, 1 or 2 person shop, and you don't know what's going to happen. Whereas with a lot of SEC firms, you're going to have more than 1 person working there, so you're going to have somebody to cover it. So that's where I think policy dictates difference. So that would really be the reason that we have succession in addition to business continuity.
Agreed.
Requirements for IA contracts, this replaces Transition Order 1, Paragraph 12. It's based on the NASA model rule, requires a lot of the similar things. It's a little more fulsome. I'd encourage you to review your contracts, review the rules, and make sure you're in compliance. To the extent you've got questions about it, reach out to an attorney.
And one helpful thing in here is historically in the statute in both federal and state, an assignment of your contract requires client consent, which would occur if you were going to have a change of control of your firm. And the SEC has for many years had a couple of no action letters about implied consent, because ultimately a client isn't going to stop you from selling your firm. They can leave if they want, but they're not going to stop you. But they do need to be notified that your ownership is changing. And so baked into the rule is recognition of implied consent, that there's notice. Clients have an opportunity to terminate their relationship. And that's really helpful, because in the reality, the transaction is going to happen. It's just making sure the client for whom you're a fiduciary knows that the ownership is changing. So that's a helpful thing in the rule.
Question.
Yeah, Sean, I believe the order was mentioning assignment, change of control being 50%, which I know is different than the SEC's interpretation from what I think is IC 40 Act, where they talk about 25%, which is kind of seems to be the industry standard. So I guess my question is, if there's change in control under the 50%, so, I'm sorry, if there's a change in a LLC structure under 50%, there's not a change in control by your rule. Does that still trigger a notification to clients if there's not an actual change in control? I mean, you could have 5% ownership change. I award an IAR 5% ownership. That's not material. But by the rule, I think it's kind of implies that you would still have to notify the client, even though there is not a change in control.
Honestly, I'd want to sit down and look at it. I haven't looked at that particular rule in depth in a long time, especially with a set of facts in front of me. I guess I'd defer, because I don't want to say something wrong, because I just don't know off the top of my head. But I can look at it and we can talk about it after if you'd like. Back here.
And I don't know the answer to that either.
Yeah, that makes me feel a lot better.
In my mind, 25% is sort of the norm for what's a change of control, and the SEC has a rule, also has a rule defining what is not. But yeah, if you have a change in ownership, you should think through and check the rule for what the requirements are.
The list of dishonest and unethical practices for broker-dealers and agents, it's really just the same idea as the IAR and IA list, in that don't do these things, please. One of the nuances that Michigan adopted, which is different from the NASA model rule on this, and again at the behest of the state bar, was to allow for family and friend lending and borrowing, or not family friend, sorry,
No,
immediate
just
family.
family.
Sorry, I was
Immediate
thinking of family and friend round of investing in my head there, but immediate family lending and borrowing. So there's a list of specific family members to whom you can lend or borrow money. provided you meet some criteria which are largely based on the FINRA list for when you're allowed to lend or borrow money to or from a client.
So important to emphasize, the general rule is thou shalt not lend money to a client or borrow money from a client. And the reason for that is basically it's the kind of activity that is often associated with fraud because there's not adequate disclosure to the client about, and a promissory note is a security. Make it very clear, promissory notes are presumed to be securities. And the Bureau and I on either side of a table frequently encounter people claiming this promissory note is not a security, it's a promissory note. No, it's presumed to be a security. And it evidences borrowing or lending, and these things are prohibited by the rules for both IAs and BDs with the exception of immediate family.
Yeah.
Not to beat a dead horse, but when the question was asked on material changes, I took a mental note back when you were talking about changes to your U4, given your credit card example. Is there a concise list someplace of what the definition would be for material changes versus non-material that one could use, say, in an annual basis to go down through a checklist and say, hey, did we have any of these? And if you don't, I would make a request that maybe put one together.
I would answer that by saying Form ADV itself and Form U4 them itself, both are your checklist. So if it's a disclosure item in Part 1 of Form ADV in the sanctions and actions kind of section, and in Form U4, and that's not an annual thing, that's within 30 days.
That's true.
So, and I'll footnote this, if anybody's also got insurance licenses, I can tell you the states vary between 10 days and 30 days. So if you have an issue that's in a state insurance license issue, it may actually be 10 days under state insurance laws, not 30. So think of insurance as having its own timetables that might not be 30, it might be 10 days.
Well, fortunately, I pay my credit card every month.
We got another question.
But I never would have thought of that.
The ADV instructions for Part 1 actually do identify specifically what's considered a material change. Part 2 is kind of case by case.
You know it when you see it, right? All right, so our last couple rules, then we'll be done. Take a few more questions if you want. We need to give the examiners time. Use of senior-specific certifications and designations. The transition orders currently cover this. This is nothing new. It's really just putting that into place. It's another NASA model rule. The last two are 6.1 and 6.2. It's just how to request an interpretive opinion and how much we charge for copy and certification fees. With that, take a look at these. Please read them. If you go out on our website, we have a copy of not only the rules, but of the regulatory impact statement and the JCAR, or the Joint Committee on Administrative Rules report. It provides a ton of color as to the why we're doing a lot of these things and what our expected impacts are. They're really helpful in understanding what we're doing here, and I'd really encourage you to take a look at it. With that, I just want to say a big thank you to Shane for taking time out of his day to come here. So if everyone could give him a round of applause, we'd really appreciate it.